All right, we're going to continue tonight with Chapter 21, Introduction to Sales and Leases. This particular chapter, we're going to cover the natures of sales and leases. We'll look at some definitions. We'll look at some fundamental principles of Article 2 and 2A, and that's in the UCC, Uniform Commercial Code. We'll look at the formation of sales and lease contracts, manifestation of mutual assent, consideration, and form of the contract. And again, we're talking about for mainly lease type of contracts or arrangements. So let's talk a little bit about an introduction to sales and leases. Sales are the most common and important of all commercial transactions. So in an exchange economy such as ours, sales are the essential means by which the various units of production exchange their outputs, thereby providing the opportunity for specialization and enhanced productivity. So again, it's just a means of exchange, right? Where we have producers and consumers exchanging the goods, in essence, that are produced. So when we're talking about the law of sales and the law of leases, really we're talking about the law of property. Within the law of property, we have real property and we have personal property. And there's almost like in this Venn diagram that we're looking at here, there's really an intersection of both the law of contracts and the law of personal property. We're talking about sales. Usually sales, again, as we mentioned, are the exchange of goods. These goods, anything that's movable, right, we consider to be personal property. The main difference between real property and personal property is that personal property is movable. Real property is usually building, land, things that are not movable. So when we're talking about goods, really goods are personal property. And so the law of sales really is kind of where the law of personal property and law of contracts intersect. And so that's what this is trying to show here. So what are the nature, what are sales, what are leases? So let's look a little bit about or into the definitions. Now goods, and we talked a little bit about goods before because UCC Chapter 2 deals with goods. And so goods really is movable personal property, and that's just what I was talking about. If it's not movable, it's usually real property. So if it's movable personal property, those are usually goods. And when we're talking about the sale, simply it's the transfer of title to goods from the seller to the buyer for a price. And that price is the consideration, which we'll be talking about in just a little bit. So what about leases? Well, a lease is a transfer of a right to possession. That's key, right? It's the right to possess and use of goods in return for consideration. We have consumer leases and we have finance leases. Consumer leases are leases by a merchant to an individual who leases for personal, family, or household purposes for no more than $25,000. If it's greater than $25,000, then at that point we don't consider that to be a consumer lease. That would really now cross over into a commercial lease. But again, the key factor here in the definitions is that the lease must be between a merchant and an individual, right? And then the individual must lease for personal, family, or household purposes. So that's key. The other thing that we have is what we call finance leases. And those are special types of lease transactions, generally involving three parties. Normally we have the lessor, which is, again, the person that is making the lease, the supplier, and the lessee, which is the person in essence receiving the lease or responsible for payment of that lease. So what's the law that applies to these transactions? Well, we have sales transactions and we have lease transactions. Sales transactions are governed by Article 2 of the Code, and again, so that's UCC Chapter 2. We've been talking about that all semester, which deals with goods. Obviously, sales for the exchange, the sale of goods or the exchange of goods is also going to be governed by Article 2 of the Code. But where general contract law has not been specifically modified by the Code, general contract law continues to apply. So, in other words, we're going to first look at the Code, see if the Code addresses the issue, see if the Code has modified the common law, and if it has, obviously, then we're going to apply the Code. If the Code is silent, then we're going to look at the general contract law principles to see what governs. In lease transactions, that's governed by Article 2A of the Code. But again, same thing, where general contract law has not been specifically modified by the Code, general contract law continues to apply. So in lease transactions as well, we're going to look to the Code, see what the Code says, and if it's not addressed by the Code or if it's silent, then we're going to look at the common law and general contract principles. What about transactions that are outside the Code? Well, those include employment contracts, service contracts, insurance contracts, contracts involving real property, and contracts for the sale of intangibles. Those types of items are not contemplated by the Uniform Commercial Code. So we look either to statutory law or we would look to contract law. So for example, an employment contract or a service contract, even an insurance contract and contracts involving real property, those are all types of transactions where we would look to the common law and in particular contract law, common law as it pertains to contracts in order to determine what applies and what should happen in different situations. So let's talk a little bit about the fundamental principles of Article 2 and Article 2A. So what's the purpose? Well, the idea is to modernize, clarify, simplify, and make uniform the law of sales and leases. And I talked a little bit about that earlier in the semester where, that's the whole point, right? The code itself is called the Uniform Commercial Code. So the idea is to make laws uniform throughout the states. Obviously, we have 50 states with 50 different sets of laws. And although the law is very similar from state to state, it really varies little, but there are some changes. And in certain areas of the law, some of those changes are actually or could be significant. So in order to avoid uncertainty, and remember, businesses do not like uncertainty. To avoid uncertainty, then we create uniformity, and that is the logic or the purpose of the Uniform Commercial Code, among other things, right? Again, one of the ideas is also to modernize. If we look at the common law goes back all the way to the 1700s, to the founding of our republic, pretty much. So the idea is to make it modern, right? Bring it and address issues that pertain to today. And also to clarify, there are many, many areas, obviously, as we begin to transact more and more business, and in particular, as business becomes more global in nature, then we need to clarify. A good example of that is the internet, right? The internet has modernized industries. 50 years ago, we didn't have the internet. So we need to clarify. We need to modernize and say, hey, what happens if there is an internet type of transaction? And also simplify. A lot of times the burdens on commerce were too extreme. So we wanted to simplify it, make it easier to do business. And again, probably, as I mentioned, one of the main purposes is to make it uniform. So whether you're involved in a lease or a transaction for the sale of goods in California or Florida or Alaska or New Jersey, we would want the law to be the same with some, obvious, some minor variations, but overall we would expect the same outcome, right? The same enforcement of the contract. One of the fundamental principles of Article 2 and Article 2A is this whole idea or concept of good faith. The code requires that all sales and lease contracts be performed in good faith. And really all that means is that there has to be honesty in the conduct or transaction concerned. In the case of a merchant and a non-merchant, if we're talking under revised Article 1, it also includes the observance of reasonable commercial standards. So we would expect merchants to follow the reasonable commercial standards, whatever those may be. I mean, those do vary from industry to industry. But again, the idea is to have that uniformity and have the merchants conform to reasonable commercial standards. There's also the concept of unconscionability. So a court may refuse to enforce an unconscionable contract or any part of a contract that's found to be unconscionable. And we talked a little bit about that when we talked about contract law. The idea, and it's actually a defense to the enforcement of a contract, and it's been codified under Article 2 and Article 2A, this whole concept again of unconscionability. And we have two different types of unconscionability. We have something called procedural unconscionability, and really what that boils down to is unfairness of the bargaining process. So if one person or one party has an unfair advantage during the bargaining process, then we would say that that is a procedural or that is procedurally unconscionable. Substantive unconscionability, on the other hand, is oppressive or grossly unfair contractual provisions. So if a contract is so one-sided that the terms are oppressive to one party or grossly unfair, right? Let's say they only benefit the seller and the buyer really has no protection. Well, that would be an oppressive contract or grossly unfair. And so a court may set aside the entire contract or a portion or a clause in a contract under this whole notion of substantive unconscionability. So again, these would be more geared towards defenses, right? So let's say you already have a contract and you're trying to challenge the enforceability of the contract, then your defense would be unconscionability. Now, there's also the concept of the expansion of commercial practices. So courts will many times look at two things or two particular items. One of those is the course of dealing between the parties. And the other thing that courts will look at in interpreting a contract or whenever there's a dispute is what is the usage of trade. So let's talk a little bit about course of dealing first. Course of dealing simply is a sequence of previous conduct between the parties that establish a common basis for interpreting their agreement. So if for 4 or 5 years or throughout the course of our dealings, we acted in a certain way, then that establishes a basis for interpreting the agreement. So if there's a dispute, not only will the court look to the contract, not only will the court look to the code itself, but the code also allows the court to look at the course of dealing between the parties and see how have the parties acted or conducted themselves towards each other. And so the court will actually enforce this course of dealing. So it's almost like an implied type of contract. There may not be anything in writing, but the manner in which we have acted in the past may create certain duties and obligations, because if we've recognized those duties and obligations in the past, we've abided by those, and those are the same terms and obligations that we've always lived by, then we can't now say that doesn't apply, right? The other thing that a court will look at is usage of trade, which is a practice or method of dealing regularly observed and followed in a place, vocation, or trade. So not only will the court look at the course of dealing, right? How have we dealt with each other? How has our conduct been throughout all of our dealings? But also, what is common in the place, in the vocation, or in the trade? In other words, in our business, what do other business people that are engaged in the same line of business, how do they act under this particular circumstance? And again, we're talking when there is a dispute over a contractual term or over a manner in which one of the parties must perform. So for example, let's assume that we have a contract for the sale of goods. The contract is silent as to when I need to make payment. You say that I have to pay you within 15 days. I say that I should pay you within 45 days. So then the court's going to look at the course of dealing. Well, how did we act in the past? When we did business in the past, did I pay you in 15 days? Did I pay you in 30? Did I pay you in 45? What have we done in the past? So that would be course of dealing. And then the other thing that the court will look at is, well, how do other businessmen that are engaged in the same line of business that we are engaged in, how do they do it? What are the terms? Is it 15 days? Is it 30? Is it 45? And so the court will look at the totality of those things and then make a determination or make a ruling as to whether we should pay in 15, 30, or 45 days. All right, so next we're going to talk about sales by and between merchants, because the code does treat that a little bit differently. The code establishes separate rules that apply to transactions between merchants or involving a merchant. In other words, when I'm talking about a merchant, it's a dealer in goods or a person who by his occupation holds himself out as having knowledge or skill peculiar to the goods or practice involved, or who employs an agent or broker whom he holds out as having such knowledge or skill. So that is how the code defines merchants. So there's a laundry list really of rules that are applicable to merchants. And so, for example, this particular slide, and it's actually in your book, it's a very good slide because it summarizes the different obligations that apply as between merchants. And also it talks about the chapter in the text where those obligations are discussed. So we begin with the very left-hand side of the column. It talks about the section of the UCC that applies, and you can see several sections there. So 2-103, 2-201. Then in the next column, in the middle column, we can see the merchant rules that apply. So the good faith, which is what we talked about before, confirmation of oral contracts, firm offers, battle of the forms, warranties against infringement, warranty of merchantability, sales and approval, and so forth. I'm not going to read all of them, but in essence, that's where it tells you what those rules are, what section of the UCC applies, and then the very last column to the far right is the chapter in the text where all of this is discussed. So again, this is a really, really good overview or summary of the some of the selected rules that are applicable to merchants. What about the concept of liberal administration of remedies and also the concept of freedom of contract? Well, most provisions of the code may be varied by agreement. So again, there's this whole concept of liberal administration of remedies. In other words, we're going to allow merchants, and we're going to allow people under the UCC to be able to kind of almost craft their own remedy, and we're going to give them the freedom to contract. So, which is also true of common law contracts, right? I mean, I keep saying that in class all the time. Two people can agree to anything as long as it's not illegal. As long as both people have the capacity to enter into contracts, and as long as it doesn't violate public policy, then people can really agree to anything. And the code allows, most provisions of the code anyway, can be varied by agreement. So if both parties are in agreement, then we can actually modify the code so that it applies a little bit differently. And it makes sense, really, right? Because the whole idea behind the code is to expedite, to simplify, right? We want to make things to modernize. So we want merchants to be able to modify the code and by agreement so that they can make it fit their particular circumstance or their particular situation, because not every circumstance and not every situation is the same. So we want to be able to give merchants that freedom and that flexibility. All right, what about validation and preservation of sales contract? The code reduces formal requisites to the bare minimum and attempts to preserve agreements whenever the parties manifest an intention to enter into a contract. So in other words, contracts under the UCC require less formalities, even than under the common law in many instances, and we're just going to reduce them really to the bare minimum. As long as we have the essential terms of the contract, then that's enough. And so what the courts will try and do is they'll try and say that there is a contract. In other words, they're going to try, if there's anything wrong, right? Let's say some of the formalities are not there. The court will do everything in its power to try and save the contract and try and hold that there is a contract, as long as the parties manifested an intent to enter into a contract. So the parties really intended to be bound, and for whatever reason, not all of the formalities were followed, or there were some missing terms, the UCC will actually supply a lot of the missing terms, including price terms sometimes. This is something that under the common law, judges are very, very reluctant to do. So again, we see this little more freedom when we're talking about contracts in general under the UCC. What about when we're talking about the manifestation of mutual assent? Remember, in order to have a valid and enforceable contract, we need mutual assent. So in order to have mutual assent, really we need to have a definite offer. So the code provides that a sales or lease contract does not fail for indefiniteness. So even if it's not as definite as it should be, even though one or more terms may have been omitted, the code provides standards by which missing essential terms may be supplied for sales of goods. And that's a little bit about what I was talking about in the prior slide, that if we're missing some of the essential terms, the code does provide mechanisms by which some of those terms can be inferred into the contract. So, for example, if you're missing a time for performance, the court will infer a reasonable time. And again, those are the types of things that under the common law, courts are very, very reluctant to do. Many, many times, if you're missing an essential term of a contract and you're under the common law, the court is likely to hold that you don't have a contract. Whereas under the UCC, it's kind of the opposite. The courts will do everything in their power to try and again, as long as there's mutual assent, right? As long as both of the parties agree and they're just simply missing the terms, missing a formality, then the court will imply those terms. What about irrevocable offers? Well, there's something called an option contract, right? Which is a contract to hold open an offer. Those are very, very common, in particular in real estate transactions. Let's say that you're a developer and you're trying to buy a large piece of land. You don't want to pay $10 million for the land if you're not going to be able to develop it for the purposes that you want, right? Let's say that you want to build multifamily housing, and maybe the zoning doesn't allow for multi-unit housing. So before you actually close on that contract, you want to do your due diligence. You want to have enough time to investigate, to look at the zoning, and to see, maybe start the rezoning process and see if you're able to rezone it. But if you're the seller, you don't want to have your property tied up while the potential purchaser tries to determine whether they can develop the property or not. Sometimes that process, can take 60, 90, 120 days. And potentially, if you're the seller, you have other purchasers that you could sell it to. So something that's mutually beneficial in, the prospective buyer wants the land, but they need to do their due diligence. So what they will do is they will actually purchase an option contract. And what that means is that they will pay the seller some agreed upon amount of money in order to hold the land for a specific period of time, whether it's 90 days or 120 days, at the end of which the buyer then has the option, and that's why it's called an option agreement. It's the option of the buyer to either close on the property or walk away and decide, I'm not going to close. So what's the benefit to that? Well, the buyer has to pay an option price, and the seller receives that option price regardless of whether the buyer closes or not. So if the buyer closes, usually that option or that purchase price for the option will be applied towards the purchase of the contract. And if the buyer walks away and decides not to close on the contract, then the seller gets to keep that money. So from that perspective, the idea is that they're compensated for that amount of time that the land is being tied up. And the amount of that option is something that's negotiated between the parties. In a $10 million parcel of land, it may be $100,000, it may be $500,000, whatever the seller believes the value of that property is for that length of time, however long that property is tied up. We also have something called a firm offer, which is a signed writing by a merchant to hold open an offer for the purchase or sale of goods for a maximum of 3 months. So again, key factors here with a firm offer: it has to be in writing, has to be by a merchant, and the idea is that the offer for the purchase of sale of goods will be held open or will be valid for 3 months. A lot of times that's used so that the person can obtain any necessary financing. Sometimes, that's usually the context in which these firm offers are sold. So while you're obtaining your financing or gathering your investors or whatever the case may be, then this offer is maintained open for the 3 months. But the key factor there is the 3 months. After that, again, there could be a negotiation period, but the norm is the 3 months. What about variant acceptances and the manner of acceptance? Well, variant acceptances is the inclusion of different or additional terms in an acceptance, and that's addressed by focusing on the intent of the party. So remember, under the common law, if when you accept there are different or additional terms, then that really is a counteroffer. Remember the whole concept of the mirror image rule. And that's something that is true of the common law. But under the UCC, it's a little bit different. So even though we may include different or additional terms in the acceptance, really we focus on what is the intent of the parties. Is it something that can be worked out? And a lot of times, again, right, the idea is for the court, or the norm, not the idea, but the norm is that the court will usually try to hold that there is a contract. Now, manner of acceptance. An acceptance can be made in any reasonable manner and is effective upon dispatch. This is also a little bit different than under common law contracts, because if in my contract I put that you have to accept via email and you accept some other way, I could actually say that you didn't accept the contract. So it's very strict, very formal. Under the UCC, we're going to look beyond that. We're going to say, look, as long as you accepted in any reasonable manner, then once you send that acceptance, that's enough. You've accepted. So really, it's going to boil down to what is any reasonable manner. And I would say nowadays, text would be reasonable, email would be reasonable. We don't use fax very much, but even fax would be reasonable. A letter would be reasonable. Any of those would be reasonable. And again, the key factor there too, it's effective upon dispatch, meaning as soon as you send it, whether I receive it or not. This concept is actually very, very interesting. It's called Battle of the Forms, and it deals with the different forms of the contract. And I'm not going to go through each of these steps, but it actually, if you start off here on the left-hand side, it tells you, you start off with the acceptance. Is the acceptance identical to the offer? And then you go through that, you answer the whole series of questions here to figure out, is there a contract that's been formed, or do you not have a contract at all? So again, this is a very useful slide it really asks all the right questions, and it allows you to follow the arrows and determine whether there's been a valid contract or not based on the different contingencies. What about an auction? Well, auction sales are generally with reserve, permitting the auctioneer to withdraw the goods at any time prior to the sale. So the way really auction sales work and the way reserves work, let's say that I have, let's say I have a painting, right, that I'm going to put up at auction. So I allow people to bid on my painting, but I'm going to have a reserve, and I may or may not tell you what that reserve is. So let's say that my reserve is $1 million. So until that reserve is hit or triggered, I don't have an obligation to sell. I could actually withdraw the goods at any time. I could do it, prior to the sale. So as long as that reserve is not hit or attained, I can always withdraw. So again, if my reserve is $1 million and people are bidding $500,000, let's say they get up to $900,000. So now I'm getting scared. They're getting close to my reserve, and I change my mind. I say, you know what? I really don't want to sell this painting, and then I leave. That's fine. I'm okay. I can do that. But once my reserve is hit, right? Let's say it's, the bidding's at $900,000. I'm afraid that, $1 million is going to be hit, my reserve. I'm not sure whether I want to sell it or not. And you bid $1.1 million. At that point, my reserve's been triggered. It's been passed. Now I have an obligation to sell. I can no longer withdraw. So that's how auctions work. And what's interesting, that's exactly how foreclosure sales or foreclosure auctions work. Very, very similar. Usually the holder of the judgment, which many times is a bank, will have a reserve. Sometimes they'll disclose the reserve. Sometimes they won't disclose the reserve. But in either case, if that reserve is not triggered or hit, they have no obligation to sell. After that reserve is hit, then they have the obligation to sell to the highest bidder. So let's talk a little bit about consideration. What about contractual modifications, and what about firm offers? We already talked a little bit about firm offers, right? Contractual modifications. The code provides that a contract for the sale or lease of goods may be modified without new consideration if the modification is made in good faith, which is not true in a common law contractual transaction. So if we modify a contract for the sale of goods, as long as we do that in good faith, meaning there's a legitimate reason why we did that, then you don't need new consideration. Again, under the common law, you would. Anytime you change a contract, you add additional terms, you need additional consideration. Otherwise, those changes or modifications may not be valid. Firm offers are not revocable for lack of consideration. So again, remember, the firm offers where the price, the merchant, right, holds the price of the good open for 3 months. So those are not revocable for lack of consideration. What about the statute of frauds? We talked a little bit about that in an earlier chapter, but the sale of goods costing $500 or more, or the lease of goods for $1,000 or more, must be evidenced by a signed writing in order to be enforceable. We talked about the statute of frauds as it relates to real property as well, right? Any real property transaction needs to be in writing. But if we're talking about the sale of goods or for the lease of goods, then there's a monetary limit. And in this case, it's $500. So it's not very much. Writing or record. The code requires some writings or records sufficient to indicate that a contract has been made between the parties, has to be signed by the party against whom enforcement is sought or by her authorized agent or broker, and it must include a term specifying the quantity of goods. So in other words, under the statute of frauds, for goods under $500, the contract has to be in writing. It has to be signed by the party against whom we wish to enforce the contract. And not only must the price be part of that term, but also the quantity of goods, right? So whether we're buying 1,000 apples, 5,000 apples, whatever it is that the contract is for, it has to be specified. So that's the statute of frauds. And as the name implies, the idea behind all of this is really to prevent fraud and fraudulent transactions in general. Now, there's alternative methods of compliance. And again, this is under the UCC. This whole chapter is under the UCC. So remember, everything that we're talking about here does not necessarily apply to common law contracts, right? This is the exception to the rule. Written confirmation between merchants, admissions, specially manufactured goods, and delivery or payment and acceptance are alternative methods of complying with the statute of frauds. So even though the statute of fraud requires that the contract be in writing, if it's in excess of $500, there are certain exceptions, or not, I guess exceptions is not the right word because there's still compliance, but they're alternative methods. They're different ways which you can actually comply with the statute of frauds. So, and I'll let you read about each of these in more detail in the book. These are pretty simple, pretty straightforward concepts, and I don't want to spend too much time belaboring the point there. Let's talk about parole evidence. Those are contractual terms that are set forth in a writing intended by the parties as a final expression of their agreement, and they may not be contradicted by evidence of any prior agreement or a contemporaneous oral agreement, but such terms may be explained or supplemented by course of dealing, usage of trade, course of performance, or consistent additional evidence. So in other words, if we enter into an agreement or a contract, it's in writing, it's signed, it's our final agreement. If that's the case, then we cannot try and modify the contract or say that, hey, we had this prior agreement and that somehow modifies the existing agreement. Well, no. If we wanted that to be part of the contract, then we should have included it. Once you sign a contract and it becomes final, then all prior agreements, all prior negotiations are what we call merge into that contract. So in essence, they become a part of that signed contract and can no longer be used or enforced. Now, the terms of the contract, to the extent that they're ambiguous, and that's a key factor there, right? If they're not clear, if we can look at the contract and the terms are clear and not subject to interpretation, then it is what it is. Whatever the contract says, that is what a court's going to enforce. But sometimes, people for whatever reason are in a hurry or are not careful and don't draft terms that are clear, or sometimes use words that can have more than one meaning. And so they create what we call ambiguity, meaning that the contract or a term in the contract can be interpreted in more than one way. If that's the case, then those terms, those ambiguous terms, can be explained or supplemented by course of dealing. Remember, right? We talked about that earlier in the chapter. Course of dealing is courts will look and say, well, how have the parties dealt with each other in similar situations? So we'll look and see and read that into the contract. The court will also look at the usage of trade. How are things done by merchants in that same line of business? And courts may also infer that into the contract. Course of performance as well, right? How have we performed similar contracts in the past? Courts will look to that as well. or if there's any additional evidence that's consistent with the contract. We will never look at additional evidence that is inconsistent with the contract. So that's a key term. It must be consistent. And this is the very last slide here in the chapter. And it actually provides really a comparison, right? The very far left talks about the section of the UCC. So it talks about, for example, the concept of definiteness. And then in the middle column, we see what contract law says about definiteness. So in the common law, the contract must include all material terms. Well, under the UCC, UCC Chapter 2 and 2A, under the Law of Sales and Leases, open terms are permitted if the parties intend to make a contract. So, in other words, what this slide is trying to do is it's trying to look at different concepts and showing you how they differ between the common law and Chapter 2 of the UCC. We also see counteroffers, we see modification of contracts. For example, under the contract law, consideration is required. Under the UCC, consideration is not required. So that's 180 degrees, right? Two completely different results faced with the same situation. So that's why it's very, very important not only to understand contract law, but also to understand modifications that are made by the UCC. The way I like to look at it is that contract law is the norm, meaning the common law is what controls, and the UCC would be the equivalent of an exception. So we look to see how the UCC applies. Remember, the UCC, though, only applies to the sale of goods. So if we're talking about something other than goods, then we would need to look at the common law of contracts. This is it for this chapter. Again, as I mentioned, we will not be covering Chapter 30 this week. We're going to be skipping that one. I think it's a little bit much, a little bit ambitious, so I want to stick to fewer chapters here. And please remember that on Thursday we're going to I decided to actually provide an extra credit quiz. It's going to be in class, so please make sure to bring your Scantrons. It's my way of trying to help everybody with their grades and improve their grades. I don't know yet how much weight I'm going to give to that quiz, but probably save it till the end and wait till I calculate the final grades, and then I'll make a decision as to the weight that I'm going to give that quiz. So if I were you, I would definitely study and try and do my best on that quiz. The quiz is based on Chapter 2, which is ethics, and it's only going to be 10 questions. So it's not a lot. Questions some are going to be pretty straightforward, some are going to be a little bit more challenging, but please avail yourself of this opportunity and make sure that you take advantage and you study. And we'll see everybody in class.